University of New York at Potsdam. Counsel?
May it please the Court, I'd like to reserve 2 minutes for rebuttal.
Of course.
Your Honors, the Third Department made 2 legal errors, and I'd like to turn first to its erroneous conclusion that the complainant's reports were rendered insubstantial simply because they were controverted by the petitioner's live testimony. This Court has always held that probative hearsay evidence is substantial so long as it's reliable.
So let me ask you this. Have we ever adopted this language that crops up in a lot of the Third Department cases and apparently now cropped up in the Fourth Department case, that if you controvert it in a way that is substantial, that somehow renders the hearsay unreliable or not substantial evidence?
Your Honor, I'm not sure, because the one case in which, of this Court in which it's cropped up, 125 Bar Corporation from 1969, I believe, it was dicta in that case, because the Court in that case announced this serious controversy principle, but then also said, well, the evidence at issue here in the 125 Bar Corp case fails on its face.
So don't we have other cases such as Vega and I suppose a number of cases in the prison disciplinary realm where in fact we have held evidence to be substantial evidence, hearsay evidence to be substantial, notwithstanding contrary testimony?
Absolutely, Your Honor, and that, if nothing else, is what I'd like the Court to take away from today, that the Third Department's holding that mere contradiction by live hearsay testimony does not render, a mere contradiction by live testimony does not render hearsay testimony per se insubstantial. And the reason...
Does the majority make a rule where a complainant must attend the hearing and be cross-examined?
Well, I mean, that's how the opinion reads, because if the complainant, according to the Third Department majority's test, again, as long as the testimony, quote, differs on a, quote, critical issue, the college or an administrative agency cannot proceed unless there's live testimony there. And that's simply not the case. It's antithetical to, A, the fact that cross-examination is not required constitutionally in the administrative process, nor is it required by the governing statutes in this area, the education law. And again, there's no...
So what should have the majority done? What was their review? What should they have done?
Their review was, first, I mean, they were perfectly entitled to examine the evidence and see the hearsay evidence and see if it was unreliable. Because hearsay evidence, by the way, like any evidence, hearsay or live, if it's unreliable, then then it cannot be the basis of substantial evidence finding. But assuming there are no reliability issues, and in a case like this, I actually counted 8 separate indicia of reliability. I hope to get through at least some of them. But assuming there are no reliability issues, as the case is here, then deference to the college's reasonable judgment is appropriate. Then there's only one question to ask. Could the college, starting with this collection of evidence...
Well, you don't disagree that if there was some sort of evidence that, some documentary or testimonial evidence that she wasn't on campus that night, that she was in another city or whatever, that would certainly be enough to rule the hearsay evidence insufficient.
I think we would be hard-pressed to defend that, again, because of some of these indicia of reliability I'm hoping to get into. Just because someone else might have testified and said that, there could be deficiencies in that testimony which would render it unreliable. But I think Your Honor is getting at exactly the right point.
So who makes that reliability determination? The hearing board? Or you're saying that the appellate division should actually look at these reliability and reweigh them? I mean, we don't generally have the appellate division reweighing the evidence.
No, you're not reweighing the probative force of the evidence, absolutely not. But this court is always entitled, appellate courts on judicial review are always entitled to say, in an extreme case, not this case, that, look, the evidence here, whatever its facial probative value, was simply not reliable. For example, let's say there was a videotape that contradicted it. Then the hearsay, while
So
probative...
why isn't it that's not what they did, however inartfully? Why is that not what the majority did? I don't know if you're following my question.
I think I'm following it, Your Honor. As I read the majority's opinion, it's certainly not what they said. They said that as long as there's, when you have a hearsay account on the one hand, live testimony on the other hand, whenever that live testimony, quote, differs from the hearsay account on the critical issue, which when the petitioner takes the stand, it always will.
So your position is that the majority, and I think we're getting back to what was stated earlier, is that they've created this blanket rule that automatically, if you have live testimony that contradicts the hearsay,
it certainly seems
good for the, for the hearing board to rely on that hearsay.
It certainly seems susceptible of that reading. That's how we read it. But let me take a stab then at convincing you that
Well,
even
before you go down that road, could we, looking at this case, say, if the complaint, in this kind of a case, on these facts, with this record, the complainant doesn't show up to testify, you can't really have the administrative entity rendering a credibility determination, because at some point it is a credibility determination. But they certainly could, because he showed up, determine that he is not credible, right? And to the extent he concedes that indeed they did have sex, that his testimony is incredible, and as a result decide that he indeed committed the offense.
the answer
Sexual
to
misconduct.
I'm sorry.
No, go ahead.
The answer to Your Honor's question is yes. The college could absolutely do that. But I want to push back a little bit on what sounded like the first premise of your question. I think there was enough material here to make a credibility determination, not a classical one as we would expect, for example, in a criminal trial. But here, it wasn't just a plain written statement from the alleged victim submitted, and that's it. We had the complainant met with two college personnel, Lieutenant Ashley and Miss Robbins, and gave her stories to them. Miss Robbins and Lieutenant Ashley, they testified in person at the hearing. So petitioner was free to, and he was asked if he wanted to.
Yeah, but they're not the ones who are going to decide her reliability.
They're not the ones who are going to decide her reliability, but...
And he has conceded that they had sex, and that they met in the way she describes.
Oh, yes, Your Honor.
It does boil down to whether or not he thought she consented, right?
No, it doesn't boil down to whether or not he thought she consented. It boils down to whether or not she did affirmatively consent. But I want to return to that point before I...
But that boils down to the view each of them have of that scenario and how the administrative entity views that, does it not?
Yes, it absolutely does.
Okay.
My...
So that's my point. Even though she's not there, they can't make an assessment of whether or not she's credible and you would believe her story. But to the extent he does show up and testify, and he agrees with part of the story and concedes part of this story, and then gives other information, that they could decide that he's not credible.
It sounds like a friendly question in part, so I'm trying to agree, but there's a premise there that I really want to...
I won't give a subjective characterization to it.
Fair enough, Your Honor, but there's a premise there that I want to continue to push back on.
Okay.
Even though she did not appear in person, and what might be called a classical criminal trial style credibility determination could not be made. There still were ways, albeit indirectly, and I'll sit down after I finish this thought, for her credibility to be probed. The petitioner could have asked, but did not ask, Lieutenant Ashley or Miss Robbins, so what was her demeanor when she talked to you? What else did she say? Was she fidgety? Do you have to pull the story out of her, or did it just flow? There were ways, albeit indirectly, to assess her credibility. Petitioner did not take the board up on any of those ways. And I'll reserve the remainder of my time. Thank you.
Counsel?
Thank you. May it please the court, Lloyd Grandy appearing for the respondent. Your Honors, we have a he said, she said, they said.
So if that's the case, why isn't it accurate as the dissent that the appellate division contend that you look at the gestalt here, they look at, what your client said, what's the complainant reportedly said to Ms. Robbins and Lieutenant Ashley, and they made a determination, they don't believe your client, and they rely on the testimony as it came in through the hearsay.
Your Honor, I think
Why
that,
is that wrong?
because my position would be, as the third department took, that when you have hearsay evidence that is seriously controverted, and this is not a minor inconsistency.
So you're going to focus on the seriously controverted?
I'm going to start there, Your Honor, and I'll go wherever we...
So if that's the case, when have we used that language? I mean, that language comes from the third department. When has this court used that language?
That is correct, Your Honor, and to my knowledge, you've not used that particular language.
Okay.
However, I do believe that it is a reasonable interpretation and a reasonable way to test the credibility of the hearsay. I mean,
But doesn't that then require in this case, the complainant's testimony in every case?
Your Honor, I don't think so, because in this particular case, if you look at the facts, and as I said before, there's a he, she, and the they. And the they part, the part that everyone agrees to, both from the live testimony and from the hearsay testimony that was put in, I think gets us to a position where if you believe all of that, and there's no reason not to, you don't have a conduct violation. I mean, I can certainly run through the parts that they agreed to.
But it doesn't end there, because it goes on, and the petitioner and the complainant from there have very different stories to tell. So, you know, I think that's just the basis. You can't eliminate everything else that they said, because that goes to the critical issue.
And I agree completely. And if the outlying facts had been close or had been reasonably equally interpreted or whatever, then that would have been something different. But in this instance, they are so diametrically opposed.
So isn't that a classic credibility determination? And if so, how does that differ from, I came from the third department, okay? So we had many prison disciplinary determination cases. And oftentimes, the position of the institution was reflected in an incident report or a misbehavior report or something like that. And the subject of the report would come in and counter with his or her own testimony what was in those reports. And as far as I know, neither the third department nor this court has ever said that that means, merely because there's a credibility determination, that means seriously controverted, and that the determination cannot be based upon that hearsay. So aren't we, if we agree with you, then aren't we upending many years of jurisprudence about administrative determinations like that?
I think apples and oranges, Your Honor. When you're dealing with prisoners, they have a specific set of rights.
Well,
They have a-
I'm using that as an example. Here we have a school, essentially school disciplinary hearing. Why is that any different?
And again, Your Honor, just to finish my thought, the prison inmates are a very specific set, and the rights that they have and the rights that they don't have, I think, mitigate to a different read than something like this, where you've got a student who's being called up. And the other thing, the reality...
Let's talk about from a policy point of view. Do we want to require complainants in sexual assault situations to testify?
And that kind of goes where I was headed, Your Honor, which is this is a unique situation, because this is not a plagiarism case or a cheating on a test case. This is an alleged rape case. And just saying the word rape carries with it a guttural response, not only for the person who's the alleged victim, but also when you're going to label someone a rapist. And I think those...
Well, hold on, all right? Because he's not being labeled a rapist here. You know, this is sexual misconduct as defined in a code of conduct, all right? And all the criminal penal law definitions of rape and what the requirements are in terms of objective evidence and things of that nature, that's not what we're talking about here. And that gets to my question, which is, here, the appellate division focuses on what they call the majority, that is, a dearth of proof as to a lack of affirmative consent. And my understanding of the code of sexual conduct or misconduct here is that there was a requirement to affirmatively prove consent. And wouldn't that burden have been on the petitioner here?
I believe that the consent is agreement by verbal agreement or being an active and willing participant. Those are the two ways that you can get to consent per the code that the school uses. And so, Your Honor, obviously you know where I'm headed with this.
I think the question is it his burden to show, or is it the school's burden to show?
Well,
Who carries that burden?
under the current guidelines, Title IX, it would be the school's burden to show. And I think that when you're going to
To show that she didn't consent.
show that she didn't consent, to show that after an independent investigation by a third, I mean, the rules have all changed, as we all know. But I do think that it's still, the serious nature of the allegations, the serious guttural connection that comes with these kinds of matters, I think require a higher level of review and a higher level of standard before
Counsel,
you're going to do that.
really, it would be difficult, I think, for this court to do that, wouldn't it? For a serious conduct violation versus what some might perceive as a less serious conduct violation. It has to be one standard, doesn't it?
Well, Your Honor, I think that there have been differences in the way that the sexual misconduct rules have been applied going forward. And I know that there are certainly even federal circuit courts that have said it has to be the same. You have to go across. And I agree with that 100%. But if you look at, and to point to the federal districts or circuits, they're leaning toward the right to view your accuser, to face your accuser.
But counsel, here you have, she doesn't attend, but much of her story is corroborated by your client, right?
That is correct, Your Honor.
Much of the story is corroborated. He concedes they had sex, he concedes they met in the way they met, they went back to her room and so forth. Much is corroborated.
Right.
So at that point, some of that hearsay is reliable and probative because you've got the corroboration at a minimum, correct? Okay.
And that's
All right,
where-
okay, let me finish. So then he's giving his version. It's certainly possible that they don't believe his version because she, in that hearsay, says, I didn't consent. She agrees to certain things that she did or didn't do, but she says, I didn't consent, right? He says, I thought she consented. But then he also says that the next day he sees a rape alert and he texts her to say, are we talking about me?
And she says no. Right.
Would that not be substantial evidence
Your Honor,
that he violated their code?
if you're going to set up a scenario where,
That even he believed at that point there was not consent.
if you're going to set up a scenario where the best way to avoid getting jammed up into something like this is not to appear yourself, I think that's contrary to what we need to do as well.
Well, there's a risk that
And
if you
so-
don't appear, that eventually the decision is going to be there's not substantial evidence. But here, much is corroborated. And he himself acts in a way that certainly could be, you might, of course, disagree, but can we really say it wouldn't be substantial evidence when there's so much corroborated and he's texting her the next day about a rape alert?
But, Your Honor, the other thing that I would point out, again, is that the parts of the story that are not that
And
they
by the
said-
way, he said, I'm heavily intoxicated, I don't remember a lot of it, I'm piecing it together.
Well, and we won't even go to the fact that the code says if you have sex with a heavily intoxicated person, that may be rape. We won't go there. But given the fact that the differences, the key differences, did they talk about whether or not they were going to use a condom? That's a really important detail that goes heavily to what happened. What was their actual position during intercourse? That's a key factor.
But those,
Right, but
those are the
those will come from-
credibility,
I'm sorry.
those are the parts that I was referring to where their versions differ, where they diverge, and that's where the board can make a credibility determination in view of all the circumstances, can determine whether to believe him or believe what they're hearing is her version.
And I would urge you that those differences being so diametrically opposed, that's where the language that I would certainly advocate that you adopt, that when there is a serious discrepancy, that you cannot rely on the
But counsel, what
hearsay.
I was pointing out to you is, let's just go with where you are at that point. Isn't the rest of what he says, the rest of his conduct the next day enough to perhaps tilt this in favor of the victim at that point? And that gets you the substantial evidence.
And, Your Honor, I would disagree with that because, frankly, because of the age of the person that we're dealing with, because of the naivete of the person you're dealing with, and again, because of the onerous that goes with allegations of this nature.
Your red light is off. Let me just ask you this
I
one
know, I'm sorry.
question. I just have one question. It's not related to this, related to the sanction. Let's say we disagree with you, we agree with the government, we think the majority erred on the substantial evidence question. Do we have to remit on the sanctions question?
Your Honor, I would think that you would have to.
Did you ask us that in your papers?
I did not, Your Honor.
Thank you, counsel. Counsel?
May it please the court, just a few...
Can we just start where he ended? Is this whole issue of the sanction at all preserved at this point or properly before us?
I think you could readily affirm the sanction based upon essentially the appellate division's dissent and their cogent explanation, but we certainly have no objection to remitting and instructing the appellate division in the first instance to consider the penalty and focus this court's review on the substantial evidence determination only. And when you're focusing on substantial evidence, as your honors were discussing, there's plenty of indicia of reliability of these probative hearsay reports. Much was corroborated by the petitioner. We've been discussing that. But also, the complainant, of course, was an eyewitness. She made these reports relatively quickly. Her first one was to the police officer that same night. The reports are at least moderately detailed. They have a who, what, when, where, and a beginning, middle, and end. It's not just I was the victim of sexual misconduct, period. And when the college is considering this type of evidence, to be sure, we are not asking this court to say that the college has to turn a blind eye to the hearsay nature of the evidence. The college is free to draw negative inferences from the complainant's failure to appear, free to give her statements less weight. But what the college is not free to do is disregard reliable evidence, such as was presented here, and their reasonable conclusion from that reliable evidence must be upheld on substantial evidence review. I just want to make one point before I sit down.
Let's see this, counsel. Let's say that, let's go with this hypothetical, that they decide on the hearsay they cannot make a determination as to reliability, but based on his statements, they're persuaded that he is not credible. Could that be enough to get you substantial evidence?
I'm actually not sure.
They just can't decide about her credibility. But much is corroborated, but they just can't decide the credibility.
Well, Your Honor, I mean, in response to a colloquy that you were having with my friend on the other side, it is the college's burden at the hearing level to prove by a preponderance of evidence that there was a lack of consent. So in the hypothetical you gave, respectfully, not the facts here, but in the hypothetical you gave where there was no affirmative evidence of a lack of consent and all you had was, I mean, we think the petitioner's statements actually supply affirmative evidence of lack of consent, namely the consciousness of guilt from the actions in response to the rape alert or the like. But if it was really just no reliable hearsay on one side and nothing on the other side, I mean, if it's a wash, then a finding of no responsibility has to issue. That's
That
not
wasn't
substantial.
quite the hypothetical. So the hypothetical is there is evidence, this hearsay evidence, but they can't reach a determination on reliability. I get your point. The burden is to get past at least 50%. You
Right.
got to establish, but there's really a wash, and part of it is because they would have liked to have heard her testimony. But he is just, they're absolutely persuaded he's incredible, even though he's corroborating. You still say they then have not carried their burden, even though they just don't believe his version, and that's the only part that's controverted, right?
Well, I mean, if they believe, I don't mean to quibble with the hypothetical, but he gives various parts of his version. If they believe, for example, the consciousness of guilt testimony, then I think that arguably could be enough. because there you have affirmative evidence affirmatively establishing, or at least allowing a reasonable fact finder to conclude that there was no affirmative consent on these facts. And that's the conclusion we'd like you to reach. Thank you, Your Honors.
Thank you, counsel. The next appeal on the calendar is appeal number 103. People of the State of New York